business. So today we have 3 panelists to present mediation for design professionals. How did we get here? So we have 3 panelists I'll introduce. First is Paul Weinberg. He is a real property attorney practicing in Irvine, California since 1979. His Orange County practice has specialized in real estate, title, leasing, and real property development matters. He has presented before 6 AIA national conventions, the last one in 2022, as well as numerous presentations at both AIA regional conventions, the Los Angeles chapter of AIA. Paul works as a mediator and has worked in that capacity since 1998, working to resolve real property, architectural, and engineering disputes. Next, we have Christine Drage, an AIA Las Vegas allied member, one of the founding partners of W&D Law. She has been a construction lawyer for over 25 years. Christine's experience includes complex litigation, mediations, arbitrations, and trials at the state and federal court levels and in tribal courts, as well as claims and risk management and extensive contract creation negotiations. She has handled virtually every type of design and construction matter and legal issue in her career, and works closely with clients and insurance carriers around the globe to effectuate consistently successful results. Third, we have Kevin McGrath, Vice President, Professional Services at Risk Strategies Company. Kevin has dedicated his 17-plus-year career to counseling, advising, and supporting the design professional community. He spent the first 9 years of his professional life as a practicing attorney, specializing in construction law and professional liability. Kevin then transitioned to the insurance carrier side of the business. Most recently, Kevin led a claims team at Berkshire Hathaway Specialty Insurance. In that role, Kevin and his team were responsible for managing and resolving claims brought against architects, engineers, law firms, and contractors. Kevin firmly believes that early and proactive intervention is the best means of driving positive claims outcomes. And with that, Paul, I will let you take it away.
Thank you, Stacy. Stacy, can you hear me okay?
Yes, we can hear you fine.
Very good. Okay. Well, good morning, everybody, and thank you very much for taking the time to join Kevin and Christine and me in this talk. We're going to talk to you at some length today about a process and a procedure that you may not be familiar with, but probably should be, because any of you that may get involved in litigation or at least an insurance claim will wind up having to deal with this system. And this talk is an outgrowth of one that Kevin and I gave in Chicago earlier this year at the National AIA Convention. And we brought on a very, very well-known and distinguished construction lawyer to assist us with this. Not that Kevin's not distinguished and well-known, which he is, although I like him better without his beard, but he doesn't like when I say that. We wanted to give you a more complete and more thorough picture of the mediation process. And the mediation process is now becoming so standard in almost all types of litigation involving construction, architecture, and negligence that it's really incumbent on any of you who is a managing partner or the office manager, people handling these types of matters, to understand how it works, how it's different from the actual trial or arbitration, and why there are so many good advantages to it through its whole process. We're going to alternate, the 3 of us, through this morning talking to you, because each of us has a particular strength. Christine's a very experienced trial attorney, has been through literally hundreds of these types of cases, both before juries and just judges, and has been through probably 10 times that many mediations, as has Kevin. And when Kevin went over to the dark side, working with the insurance industry, he wound up having to deal with people like Christine in understanding what the benefits of mediation are and how a good claims person can work closely with the architect's or design professional's lawyer to ensure a better outcome. So we're going to start, when we were planning this, Christine brought up the excellent point. I was going to start with defining mediation, and she said, we need to understand better, how does it get to the mediation process at all? And Christine, I'd like you to talk for a little while about that particular topic before we dive into the mediation process, please.
Great, Paul. Thanks, everyone. Good morning. Good morning, Kevin, as well. And we had a discussion about, obviously, the purpose of this particular presentation is really the nuts and bolts of mediation, why it's so important, what it is. But I want to take just maybe 5 minutes maximum ahead of time to talk about, how do you get into mediation? What types of legal disputes do you see as design professionals? So what types of legal disputes, what facts do they involve? What technical claims do they involve? What legal claims do they involve? And then, of course, the main focus is, why is it so important to get your legal dispute into a mediation process early, often, sooner than later? So let me take a step back and talk about, first of all, what types of projects do architects and engineers of all disciplines see themselves involved in? What kind of lawsuits come your way? And many of you have either been through the process, or you've been a witness deposed in the process, or you're in the C-suite where you're dealing with decisions about whether or not to settle a case, even though you didn't do anything wrong. But the general type of case that you'll see as architects and engineers, it used to be a theory, right? There's a lot of data out there that, oh, only if you do mass-produced residential housing do you end up in litigation. So if you do public works projects as an architect or engineer, you're not going to end up in litigation as much. And the reality is, litigation will be part of your practice. Therefore, and regardless of the type of practice you have, public works, private works, commercial, residential, hotels, casinos, you name it, litigation is going to be part of what you have to anticipate and plan for.
And I would just say, Christine,
yeah, go ahead.
On public works projects, I've actually seen an uptick, because you're dealing with a lot of fixed cost bids, and those bids are not necessarily done off 100% complete design documents. So, and especially in a design build project delivery method, but you're seeing the contractor, they have no other option than to bring a claim. They can't get a change order pushed through because they're on a fixed cost bid. So I think it's actually going in the other direction, where public projects might have more frequency of claims now than the residential projects or private development that you mentioned, Christine.
And I agree. I personally, in my law firm, we've seen an uptick that, during COVID, and then the evolution of the claims after COVID. And they are everything from, what you saw before COVID, which was low bid contractor comes in, wants to make up that low bid through change orders, alleged delays, cost overruns, necessary design changes get on the table, and you end up in litigation. Now it's even compounded. Projects weren't naturally delayed, have it be force majeure or otherwise. For some reason, the construction industry was allowed to continue working through the process, which on the one hand was a benefit. On the other hand, the claims have magnified exponentially. So we are seeing many delay and cost overrun claims. They're not construction defect claims like you see on the residential housing, but they are expensive delays, cost overruns, and multiple parties involved in all of the lawsuits. So I agree, at this point, it's all of them. After 25 years, I've seen it all. I've seen every type of case involving every type of delivery method end up in litigation, which is why I was eager to join this panel to talk about mediation, but you name it, tunnels, airports, sinking buildings, delayed casinos, you name it, I've seen it and have litigated it. And importantly, for this topic, 99% of them resolve in mediation before trial, or before a jury renders a verdict, or an arbitration panel renders a verdict. Why is that important? If it's all going to settle anyways, because these trials take 6 months and they're ungodly expensive, why wouldn't you try and mitigate your risk up front through the mediation process? So I won't jump ahead. Let's look at just next kind of what type of technical claims are involved in the litigation you see as architects and engineers. The standard claim is that you all fell below the standard of care in the preparation of your plans, specifications, calculations, construction administration services. Every owner out there seems to want to make you all design professionals the eyes and ears of the project, even though you're likely not paid to have that scope of service. Every owner's lawyer out there wants to conflate the role of an architect and engineer in construction administration with the role of a general contractor supervising means, methods, techniques, sequences, and procedures of construction. So you end up in litigation and you end up in mediation discussing issues like that, which are technical issues. And then you are also concurrently fighting on the legal front, the legal issues. So what are the legal issues? Everything is based upon, really for the most part, the contracts and the statutes. So your contract is going to be hugely important, not just a mediation clause, but other provisions in there that shift responsibility away from you. And then there's some that are shifted towards you, understanding the legal ramifications of what you signed up for in order to ultimately prepare your resolution and understand why you might have some technical and legal exposure is really important. So you'll
Christine,
have.
let me just interrupt you for a
Yeah,
moment.
Paul, go ahead.
When we were talking, the three of us in prepping and planning, both you and Kevin made the point over and over that scope of work in the contract was such a critical element in how these things play out, whether people give some thought to how that's done, when it's done, what services are included and what's not. Could you speak a little bit about that in the context of what you're talking about, with mediation?
Very important, very, very important. Here's a great example from a recent case I had involving a justice project. The names will not be shared with anyone, but the scope of service for the architect clearly delineated what they would do and what they would not do. Okay, and that was very important to have that in writing in the contract, or at least to have a provision that says, we, the architect, are going to do all this, and we're not going to do any of the below or anything not expressly articulated in the above. So there's no question about what this particular architect was going to be doing. Ultimately, low bid contractor sued the public entity owner for delays and cost overruns, claimed that, among other things, my architect was responsible for management control of the BIM modeling. Okay, that wasn't in the contract. It took me waving that contract around for 6 months, convincing everyone involved on the other side why, sure, if there's issues with BIM modeling, and that can happen on projects, but on this project, it's not my architect's scope. It's not my client's scope. That was, the owner took that on, and it looks like the owner then delegated it to a very expensive construction management firm. Super, but don't sue my client over that. If I didn't have a very clear contract about what was included in the scope of services and what was excluded in the scope of services, I'm then fighting a legal battle in a lawsuit with an owner's legal team who will say whatever they want to say to shift liability to my architect or my engineers. And it's not okay. But that's the problem. That's what you end up with. And the confusing or incomplete or vague scope of services is really, for me, one of the reasons you end up looking to your clients and say, listen, I know you didn't do anything wrong. I know that wasn't your scope of service. I know you weren't paid for that, but this is why you want to consider possibly resolving this for X, Y, and Z. Here's what's going to happen to you with that contract. So I could go on and on, sorry.
Yeah, I just have a few things to add on that too. Christine mentioned, it's very important to define the scope of what you are providing, exclude what you're not providing, but also provide for language that allows you to perform additional services. And you can provide a list of what types of additional services that they might be. But if you do agree to provide additional services, it's important to also have language dictating how you'll be paid for them. But it's also a smart idea to further codify in writing, what those additional services are, so you don't face the creeping scope type of argument that we always see. And that's the second point I want to make is course of conduct can also alter what your contract language says in terms of scope. So it's really important for the people in the field to understand what the scope is and not go above and beyond that scope, because allegations that your scope changed during the course of the project based on what you did and didn't do in the field a plaintiff can't prevail on those claims, right? So it's really important to have your team understand the scope going into the project, and also to constantly remind the other parties on the project in writing what your scope is and why something might be outside of your scope. And one other thing, one other thing I wanted to mention too is when I'm reviewing a contract and giving advice, I like to also add language stating that the architect or engineer or the design team will not be responsible for information provided by others. Oftentimes, a geotech, for example, is not retained within the design team's umbrella, but you're relying on that information. So any design services that are provided by an owner's consultant or a contractor's consultant, if you're relying on that information, it's important to say in the contract that you're entitled to rely on it and no liability will arise for inaccuracies in that information.
And to those, I agree, Kevin, and to that end as well, I still hear in the industry when I do different seminars or I'm representing different clients, and I'll hear, especially the younger design professionals, ask, are contracts really enforceable? Isn't it that none of this, you end up in litigation, the contract doesn't matter? And I really have to emphasize that the contracts are absolutely enforceable. If they are negotiated at arm's length and fully executed, a court more often than not, there might be some exceptions, is going to enforce the four corners of that agreement. Now, the agreement can be 200 pages or it can be a Post-it note.
Right.
And so the first thing I ask for in every single case I get in my office is let me see the written contract. And as you can imagine, the response is everything from we don't have one, or we have one and it's not signed, or we have one, it's 150 pages. And then you got to go and cross-reference it with the general conditions and the contracts with all the other parties, which is super, but it's all enforceable.
Well, there's also my favorite is it's pursuant to a master services agreement, but this job is a little different than what you provided. Those are fun to deal with too, right? But yeah, there's all types of contracts.
And then that's you look at the legal part of the litigation that just came in your door. And the first thing you look at is the contract. You look to see, is there a resolution provision, mandatory mediation as a condition precedent to any lawsuit being filed? Wonderful clause, and Paul's going to talk about that later. But then you dig into the risk management provisions in each contract, which then starts to shape my job, my recommendations to my clients about what can and can't be done, even if I know you didn't do anything wrong. If your contract says a whole bunch of things, then there's going to be a gray area where you want to try and get things resolved before you spend a lot of money on me, before you spend a lot of money on people you don't want to be around. So that's important, I think, leading into this discussion on mediation. And some just additional points before we jump into Paul talking more in detail about mediation. Rarely will litigation that involves an architect or engineer only involve two parties. So if you get stuck in a piece of litigation, you're going to be sitting in a room with the owner's lawyer, general contractor's lawyer, probably 6 specialty subcontractor lawyers. You're going to have the architect's lawyer, the architect's structural engineer is going to have their lawyer, and so on and so on and so forth. It's a multi-party beast, and it is a party you don't necessarily want to be invited to, and it's one that you want to figure out what your exit strategy is, just like any party, right? Like, how the hell do I get out of this party? I'm going to show up for 5 minutes and then I'm going to leave, right? Similar to this, look at what will happen at that party and then figure out your exit strategy through mediation. Additional note that I want to talk about before handing it over to Paul is, how do you get a lawyer to represent you in a construction dispute involving design professional services? And just preliminarily, it's a tripartite relationship. So you want to have a lawyer who represents architects and engineers. There are many of them like me. We also have relationships with the insurance companies, and we work in a tripartite relationship with you, the client, and also you, the insured. Why is that important? Every project you work on requires you to maintain a certain level of professional liability insurance, whether you want to or not. If you're working on any type of project, you should go get that insurance to protect yourself. In addition, the insurance companies certainly want not only keep you as a satisfied insured, but navigate you through a process with sophisticated counsel who are going to help you understand. I've seen it thousands of times. Kevin has seen it thousands of times. And you, the client, maybe you have, maybe you haven't. But chances are you have not seen litigation thousands of times. So rely upon your insurance company, rely upon your counsel who will have a relationship not only with you, but with that insurance company to navigate you early through this litigation process.
Yeah, and I'll just add real quick, and that's where the insurance carrier selection becomes so important. I think there's, at last count, there was 56 different insurance markets offering professional liability coverage to design professionals. Not all are equal, right? I would encourage you to find a specialist carrier that understands the process and understands the nuances that hiring someone like Christine and willing to pay what's maybe a slightly higher rate will lead to a much better outcome for your firm than hiring a panel counsel who does typically practices general liability insurance, maybe does a lot of auto accidents or slip and falls, right? You're not going to get the same result. And additionally, those same carriers oftentimes have sophisticated claims people too, who add value to the process instead of become a roadblock to resolving a matter.
And if I can add to that, it is really important. And I see this in cases that I've had reassigned to my law firm, and then I've seen it in opponents and others in some of the cases where, you know, the word design is used very loosely, right? And if your lawyer doesn't understand the difference between plans, specifications, shop drawings, why specifications are actually part of the contract documents. What are the contract documents? Not just a contract. There's a whole list of what the contract documents are, and they're all binding and they're all informative, and they will inform whether you win or lose your case if it ultimately does go to trial. And there are lawyers out there who might dabble in construction law. They might dabble in real estate law and think that somehow that all cross-pollinates, and it really doesn't. So listen, I'll be the first one to say, I don't know a thing about family law, criminal law. I mean, most anything, but man, I know my construction law. And you want to have your lawyer know your construction law, know construction law. Don't just dabble in it, because I'll get in a case of 2 years later, someone hasn't even peeked at the CM agreement on a public works project to see whether or not there might be defense and indemnification, just things you look at and you wouldn't know unless you had years and years of experience as a construction lawyer. So be careful with that. It's important, and it's going to be money well spent, at the same time with the goal of getting you back to business quicker than having you drag through the legal process in the US. Okay, that was a lot longer than I intended it to be.
Okay.
Yeah, and we're going to dive into a lot of the points that,
Sorry.
yeah, and a lot of the points that Christine made, we're going to elaborate much further on. So, happy to field those questions as we get to that part of the presentation.
Okay, we do need to dive into this basic definition of what is a mediation and what happens in a mediation, what each person or entity's role is. And there's a common misconception. Interestingly, Kevin, we saw this a lot in Chicago, where people, using Christine's very accurate word, conflated mediation with arbitration. And they had a misconception of what mediation was and is. Mediation is not a dispute resolution process in the sense that I or any mediator can't make anybody do anything. It is a voluntary, generally voluntary process where the parties, their counsel and insurance representatives get together in an informal setting to discuss potential avenues of resolution between them, allocation of liability, fault, costs, things of that nature. It is now the preferred method of resolution across the country for construction disputes. It's very, very rare that I have seen a court, certainly here in California, that does not badly want mediation to take place before the litigation proceeds too much further. Christine and Kevin both deal regularly with what's called a case management order, which is a document that the lawyers collaborate on at the inception of the case. And I have yet to see one that does not have mediation provisions in it, where the court essentially orders mediation before the case goes too far along, when there's a chance of resolving it. Amicably is a little bit too nice a word, but prior to trial. It is non-binding. It saves litigation funds. It allows certain amounts of limited discovery to get ready for the mediation. And it is a non-judicial process. When I mediate a case, there's no judge breathing down my neck. It's not being recorded. And I'm not having 60 people at an appellate level second guessing what I did. What I did is what I did privately and with the best of my judgment to try to coax people to resolve something. The reason I get away with that is that I can't make anybody do anything. And what I do isn't binding unless everybody agrees and it's written up. And we'll talk about that at more length a little bit later in the talk. But I want everybody at the inception of this part of the talk to understand mediation is not arbitration. It's not trial. It's not binding. It's an informal discussion with the parties and their counsel and the insurance representatives about potential liability, pluses and minuses, and so on.
I would just add, Paul, it's not only the preferred method of resolution for judges, and I think the three of us, but also insurance carriers look favorably upon it, right? They're going to ask at the time they're underwriting your account whether or not you use AIA standard agreements, right? And those include a mediation clause. And insurance carriers don't want to see arbitration clauses because the results are far more uncertain and can lead to greater losses on their end. So it reflects favorably in your premium that you pay if you are using the AIA standard documents and have a mediation clause in your contract agreement.
And I am still asked that question also, you know, what is the difference between mediation over here and arbitration over here? And arbitration might as well be a judge, right? But it's a judge you choose, but it might as well be a judge. They can decide. There are some nuances there where you can't appeal in arbitration, but you're on the same track where you're giving up control of your outcome to someone else ultimately. So in a trial, it's a jury or a judge. In an arbitration, it's a panel of arbitrators or one arbitrator who's ultimately going to decide your fate. All right, great lawyers, we can do a lot of great things, but ultimately we cannot control the outcome and that decision. Mediation over here is your chance to get before a mediator in a non-binding setting. The mediator can tell you your case is awful and you should settle it, and you can get up and walk out the door because it's not binding. But it's a chance for you to control your outcome and not turn over your case to jurors who might not understand the difference between, you know, rebar being cut at Harmon Tower and your role on the project. So it's important to understand that's why mediation, it's something you don't just have to avail yourself of one time. In fact, in the complex cases, there are ultimately many mediation sessions that are needed to resolve, you know, thousands of issues. But it also can be one session that can resolve if reasonable minds want to sit down and actually go work instead of litigate. Those are going to resolve early. Anyway, go ahead, Paul.
Yeah, and I'd also add that in my experience, a lot of the times that when you're selecting a panel of arbitrators or a single arbitrator, a lot of the choices I feel are people that have more of a connection to the construction industry and a specialty in construction law versus the design professional side of it. So if anything, you're going to get a bias towards the contractor side of the argument when you're looking at making that choice of an arbitrator, which is obviously not ideal.
And I mean, I tell you from a litigator standpoint, I agree with that. And apologies to any arbitrators who are listening, but at the, you know, it is, you know, often general contractors who end up in a lot of litigation with subcontractors end up in arbitration and resolving their disputes. And these arbitrators are indeed sophisticated arbitrators. They know what the contractors and the subs are trying to do to pass it on to the design team. But it's not necessarily a safe haven for you if you say, well, I'm going to arbitrate instead of go before a judge. And if there is a chance that there has been a breach of the standard of care in the industry in your case, and you can't resolve it because the dollars are too much, there's too big of a gap between the resolution and what the plaintiffs want, you go before the arbitrators and you're going to be looking at a rare event to have a complete defense verdict. So I can go before a judge and get a defense verdict. All right, it's not my recommendation, but I've had cases where the parties are so unreasonable on the other side. It makes my life easy because we have no choice. My client has no choice. All right, we're going to go and I'm going to win, and I win. But it is expensive. It is agonizing for you, the client. It's my job. I happen to be an ex-athlete. I love it. But it's not the route you want to go in. And quite frankly, it's the same for arbitration because the end result is you're not going to get a defense verdict. And more often than not, they're going to split the baby. So you go in with a $100 million claim and okay, the arbitrators might do you a favor and only assign the $50 million of liability exposure to you. That's not what you want to be listening to at the end of an arbitration. Doesn't always happen. I've definitely had arbitrations with sophisticated arbitrators who will allocate fault. And it's important to find those guys or gals. But it's more difficult. So again, you back up and go, okay, before I go to arbitration, the actual proceeding, before I go to trial, the actual court, I want to try and give mediation, informal, non-binding resolution, a chance. Now, when I say non-binding resolution, ultimately, if you reach a resolution, it's binding. So memorandum of understanding gets signed, it's binding, and the case is over in the mediation process. But do it before you get to arbitration and trial. Paul.
Okay. I think all of these are very good points. And I've been getting a lot of questions in the chat room. And unfortunately, I'm not a really good multitasker in the sense that I can pay attention to what everybody's talking about and respond to these. So please bear with us. We have allocated a full half an hour at the conclusion of this to answer everybody's questions at length, and we will. So please bear with us, but we've got a fair amount of material that we do need to cover. And if I'm answering the chat, I will do a very poor job of covering my part of it. One of the points that I want to make in the mediation process, why it's such a big advantage, is it stops the litigation cold. If you resolve something in a mediation, the case is over. If there's a written agreement between the parties that comes out of the mediation, there's no more lawsuit, no more depositions, no more discovery, no more stress, unpleasantness, sleepless nights, as well as an enormous amount of money going out the door for the payment of the deductible and also any other fees that are involved. It also preserves the confidentiality of what is said. And I want to talk just very briefly about that. Here in California, we have a law, and I imagine Nevada is the same, that anything and everything that is said to a mediator in a mediation is confidential and cannot be used for any purpose in a judicial proceeding or in an arbitration. And it's really the linchpin of how I get cases settled, because people can and will tell me things that they won't tell anybody else in a mediation. And I can factor that into my thinking about how to try to settle a case. So not only is the process more informal, it also has this confidentiality shield attached to it. And in California, the case law is a case called Cassis, but there's quite a number of them that protect the mediator and the parties from any kind of intrusion or discovery into what was said in the mediation. And we had this huge fight here in California, which the three of us talked about, this idea of where the Judicial Council wanted to break that confidentiality if there was a malpractice case. And everybody, including me, came out swinging, saying, no, 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 no. In fact, the California Judges Association led the fight and said there's not going to be any break in the confidentiality provisions. So now what the Judicial Council basically did here is require the lawyers to give a disclosure to their clients. Well, if you go to mediation and I screw up, too bad. You can't use anything in the mediation against me because it's all confidential, all confidential. I want to talk with Kevin for a moment about this idea of when you proactively attempt to resolve a dispute, how does it save money and affect your loss runs, your loss history, and how the insurance company looks at the architect as a client and as a customer? So if you wouldn't mind, Kevin, talk about that.
Yeah, no, it's really important, Paul, and I'm glad you brought that up. So everybody who carries insurance knows that you pay a premium for that insurance, right? What you might not understand is the process of how to determine the future premium you will pay, right? So once you have a claim on the books, if that claim goes outside of your deductible and the insurance company spends money defending that claim and or settling that claim, that all goes into your loss ratio. And that's simply a calculation of what the insurance company has paid, and that's defense costs and indemnity costs, because design professionals policies are eroding limits policies by nature. That number will be added, right? And put up against the premium you've paid over however many years you've been at that insurance carrier. And the insurance carriers will look at that loss ratio, and the higher that is at the time you go to renew, the higher your pricing is going to be. And those losses stay on your loss run for 5 years, sometimes more, depending on the carrier. So your premium could jump dramatically after you've experienced a lawsuit, right? So what I encourage design professionals to do in the event of a claim is to not dig their feet in the sand, not want to take something to trial on principle. You need to understand the entire dynamic and understand what's best for your firm looking forward several years. And oftentimes you're going to get a defense budget from someone like Christine. You can understand what the projected costs might be to take that matter to trial or through trial, and you can use that money instead of defending the case towards settlement. And it's sometimes a hard pill to swallow, but at the end of the day, understanding your costs might dramatically go up, and oftentimes professional liability insurance is the biggest line item for design firms. Understand your best position yourself from a financial standpoint moving forward.
Christine, can you add to that, please?
Thank you, Paul. Just to add, I'm sure the hair went up on the back of the necks of some some participants in the call
Yes.
where in general, the thought of not fighting on principle, when you didn't do anything wrong, when you feel like you're being sued because it's some extortion, some setup, it's an awful feeling. There are definitely cases where the facts will line up, your contract will line up, and you're going to fight on principle. And my marching orders as your soldier are going to be, you go fight this case, Christine. And the insurance companies, once they have been fully informed about all the pros and cons, are more often than not on board. But a lot has to fall in place on the insurance side and on the legal and technical side of your case to then fight on principle. There's nothing wrong with fighting on principle in this industry. And we see it with doctors in medical malpractice cases. We see it with lawyers in legal malpractice cases. We worked our butts off to get these degrees as professionals, and we're not going to just let someone sue us and make something up without fighting it and sending a message that we want to win and we're going to win and we're not going to tolerate it. Once we get through all of that, okay, most of the time, there are many important legal and technical reasons why fighting on principle is the worst business decision you can make. And if you want to keep your business and you want to keep working in the industry, then getting it into mediation as opposed to litigation is really important. And I looked at at the chat room briefly, just one of the questions kind of I could talk about now. Why would you give up your right to sue? You're not giving up your right to sue if you don't want to give up your right to sue. So if you get sued, let's say by the owner, you get sued by MGM, right? You, the architect or engineer, are now a defendant in the MGM lawsuit. Yet MGM owes you $500,000 in fees. You're going to be suing MGM back for recovery of your fees. There's nothing wrong with that. There are a lot of steps that need to take place in order to make sure that you not only have good defenses against the claims that you screwed up your project and your plans are awful, and a lot of things need to take place to make sure you preserved your right to legally and factually to go pursue recovery of your fees. So no one's asking anybody to give anything up front. Lots of analysis goes into this and lots of preparation before recommendations are made by people who've seen it 1,000 times, like me and like Kevin and like Paul.
Yeah, and a mediation actually you're not giving up any right. It's mediation, if you agree to it via contract, is a condition precedent to suit being filed, right? It encourages the parties just to sit down and talk about the issues and try to resolve that prior to everybody spending a lot of money on lawyers, right? So it's not in any way, shape, or form giving up your right to sue, where in fact an arbitration clause, on the other hand, is actually giving up your right to sue. You're in a similar setting where the dispute is going to be resolved and litigated or arbitrated in this instance, but you're not getting the benefit of all of the protections that the legal system affords, in my opinion. And just going back 1 second, Christine, on digging your feet in the sand and standing on principle in a matter where you feel that you've been unfairly targeted. One other important item to consider is that insurance carriers have in their policies with you, which is a contractual agreement itself, what's called the hammer clause, right? So insurance companies often require your consent to settle a case. They can't just go and do it on their own. But however, if you're at a mediation and you have the chance to resolve a matter for $100,000, but you refuse to do so because you don't think you've done anything wrong, the insurance company can then invoke the hammer clause, which means if you go to trial and the losses are greater than $100,000, say they're $200,000, you're personally responsible for that extra $100,000. The insurance company will not pay for it because you had an earlier opportunity to settle for far less. So that's something to consider as well during the dispute process. There's downside risk, and there's ways that the insurance company can shift the risk away from themselves and back onto the design firms.
And in addition, another point, not on that point, mediation, just a reminder, can happen at any time. So yes, there are contract provisions where it's something that has to happen before any lawsuits can be filed. More often than not, lawsuits are filed and then the parties map out when they want to actually mediate. A lot of times cases cannot settle until there's a real healthy exchange of information, of documentation, of specific project file documentation, depending on what the issue is. The parties need to exchange contracts. The parties need to exchange the applicable change orders at issue. If there are some hot meeting minutes, right? So you want to have that workup done. So you're going in to a mediation educated, which means mediation can happen at any time after that point. It is something that is voluntary when litigation is filed. And what typically happens is the lawyers get in touch with a mediator. Everybody has to agree on who he is or she. And they'll say, okay, we want to try and set this for mediation in 6 months. And in the meantime, we're going to do some homework. And then we'll come and we'll educate you, the mediator, and everyone will be educated on why it's not our fault or why we need to be a little bit worried about something. So it's not something that you can only do one time. You can do it early, often, before litigation, during litigation. A lot of times these cases do get mediated on the courthouse steps at the time of trial. Those are the ones where I go, at some point, why wasn't this mediated earlier? But often there are reasons why it doesn't get resolved earlier. Usually one party or more are unreasonable, in my opinion. But anyways, mediation is a tool you can use often.
Okay, I want to talk now literally like we're walking into the room of what happens in a mediation and who comes. And Kevin and I talked about this at some length, where the mediation will take place in a neutral place. We have a very large conference room in my offices, with several of them actually that we use, but I've also gone off-site and hired conference rooms if the parties are in another city where it's too long for them to drive down to see me, particularly in LA. I'll go up to LA and we'll do it in Los Angeles. Mediators do their job differently. Some mediators like to jam everybody into the same room, have them yell at each other and see if anything comes out of it. I'm really literally the opposite. I put everybody in private soundproof rooms, some physical distance away from each other, with their lawyers, with their insurance people, so they feel they're not going to be attacked. And then I wear out shoe leather regularly, walking between the different rooms to find out what each party's position is. And I like the exercise. I like the peace that comes from people not having to posture, because a lot of times when the lawyers are in the same room, they feel like they have to put on a dog and pony show for their clients to show how tough they are. All that does is poison the well, make my job harder, and leads not to resolution, but more anger. So mediators have different styles, and we'll talk about different mediators now. They do what they do. But I think that it's important to take the temperature down, not up, in these types of a process. Several years ago, when we were all stuck with the COVID-19 crisis, mediation shifted to virtual from in person. I actually spent about 3 months in a course with a man, strange enough, in Hawaii, who taught me via Zoom how to conduct Zoom mediations. And I've probably done 30 of them, I would guess, during the 2 years that COVID was really rampant. I don't like them. The reason I don't like them is I can't get a sense of a person on a TV screen like I can when I'm actually meeting them, shaking their hand and taking their measure, just as they're taking mine. I think interpersonal contact in a mediation is critical to gain the trust of the clients, to gain the understanding of the attorneys, to set a tone, and to read the room to understand when something is in a position to settle or when it's not. Many, many times in my career, I've had lawyers take me by my admittedly not huge bicep outside the room and say, I want to talk to you alone because my client's being a bleep and I need your help to stop them from making a self-destructive decision because I can't get through to them. I need to know these things because that's how I get cases settled. If there is a rift or a divide between the lawyer and the client, I need to understand that to see if I can repair or heal that rift, or at least understand why it's there. That's why I'm such a big fan of the interpersonal rather than the Zoom or disconnected. Body language, facial expressions, other personal characteristics I can look at and draw conclusions from is a big help. In the last 6 months to a year, I've done a lot of hybrid mediations where I've had most of the parties there, but the insurance people are often on the East Coast, and it doesn't make economic sense for them to attend. So we set up a dedicated Zoom link for them where they're on all the time, and I'll talk to them and try to reason with them, not always successfully, but try to reason with them. And we make a lot of progress that way as well. I'm very understanding of the economic constraints in having everybody show up. but I need the parties and I need their lawyers. Any way I can get that in person. I'd like, Christine, if you would to comment on that, what your experience has been like and how you feel about that particular point.
Well, it's tough. I mean, I've done it all. I had to do Zoom mediation, Zoom deposition, Zoom trial, and adapting to the technology, the confidentiality, the rules of the road from a technology standpoint, making sure that all of the glitches that happened early on, people not knowing where to mute it, not knowing that the rest of the room could hear them, not realizing that when they were sharing a screen of confidential information, but didn't have it in a confidential chat room setup, I could see everything. I mean, it was comical if it wasn't tragic at times. So I come from, I became a lawyer in 1993. So I come from a time where you hauled your butt into court, you hauled your butt into the conference room, you hauled your butt into the office. So but with that said, we have to adapt and we have to adjust. So I have clients all over the country, headquarters all over the country, all over the world. And if they can't make it and their physical presence is going to prevent my case from procedurally going where it needs to go for them, right? If they can't be there, then all right, but we really want to try and make an effort at resolution through mediation, then I'll do a Zoom mediation. It's not my first choice at all. I agree with Paul. It's really important. I mean, even in depositions, it's important for me to put eyes on people and the people around them. And in the Zoom setting, I know there are 10 people around the guy I'm deposing. Or in a mediation session, I know that there's another room of people listening in or participating in the mediation, but I can't see them. And that's unnerving and counterproductive in my opinion. So again, ideally don't like the Zoom, but it can be done and it can be done successfully. It's just not the first choice.
Kevin, your thoughts?
I would agree. Paul, you mentioned, building trust by being face to face with someone in the same room. And that's absolutely important when it comes to the mediator. Everybody's got to trust the mediator, but when you're as a decision maker on one side versus another side, what you also lose is the ability to read that body language that you mentioned and facial expressions. You lose a competitive advantage, right? Because it was really difficult for me during Zoom mediations to understand where I could apply pressure and push for a better outcome, right? And I think you lose that to a certain extent when you move online.
And something I always say is that everyone, in order to have successful resolution of any case, everyone has to have skin in the game.
Yep.
So everyone has to be mutually inconvenienced, all right? So if everyone goes into a conference room mutually cranky that they had to travel to get there, and they're actually there, it means they want to settle the case. It means they're going to be grumpy, they might posture, but at the end of the day, there's a signal that the case has a chance to resolve, maybe not at that session, but at future sessions. And the Zoom mediation just allows parties to opt out a little too easily. And it's they're not as inconvenienced and they don't have skin in the game. So another reason why I really in person, if you can do it.
Right.
Okay. And one last point for you, Christine, before we go on. When you're going into the mediation or prepping for the mediation, you and I have talked about this idea of the architect absolutely has to be there. And there's a possibility you may want an expert or somebody else with you at the mediation to bolster your point of view. Can you talk for a minute about why you like doing that and what the advantages to you and your client are?
Well, let's say I'm representing an architect on a complex transportation project, right? I am not an architect, but I'm a lawyer who represents architects and has done that for 25 years. One of the first things your lawyers do is, in conjunction with the insurance company, scout out the best architect expert, right? Who do we want on our team? That doesn't mean we have to go spend money on him or her, but what experts do we want to have analyze our plans, specifications, project documents, other contract documents to find out if, in general, the standard of care was met. And it brings, if you bring that expert to the mediation, if that's something that you as a team have decided to do on your behalf, that, if the insurance company's on board, we feel that we need to have the architect come in and explain, technically speaking, why this particular specification, this particular plan detail didn't violate the code applicable at the time. It's valuable and it's more credible. So I can come in and posture, super great at it, right? And I know everything that I can get fed to me by the best experts in the world. And I'm going to be able to then translate it to a mediator and a judge and a jury eventually if I have to go down that route. But it is more credible if the owner of MGM or the owner of the public entity, you know, whatever we're talking about on the other side of the table, is hearing from a guy or a gal who actually was an architect of record for this type of project. So if I have a stadium and I represent the architect and the allegation is the stadium is defective and it's late and it's over budget and it's your architect's fault, I'm going to have my architect expert come in, and this architect is going to have a ton of stadium experience. He's going to be from one of the big firms, maybe retired, but he's going to come in and say, based on my experience as an architect of record designing Dallas Cowboys Stadium and every other stadium in the US available to that firm, here's why this is the way it was done. Here's why, Christine, your client met the standard of care. It's really valuable on many cases. There are certainly cases where you don't want to spend the money on experts yet. And then my client, who's a design professional, can come in and explain in detail in a mediation setting why he or she or the firm didn't fall below the standard of care. And in that case, you'll save a lot of money on expert fees and costs. But there's, you know, the expert assistance is important. Structural engineering is a great example, represent a lot of structural engineers. You know, there's not, if I'm listening to a lawyer on the other side of the table, even if he represents structural engineers for a living and might have studied engineering in law school or before law school, it's like posture, posture, posture. That's great. Who's your expert? Now, if you bring an expert in to say that the structural engineering was below the standard of care and the calculations were bad, my client's going to listen, you know?
Yeah, and I would add a couple things. I mean, Christine mentioned retaining that expert early. I concur with all my heart. If your insurance carrier and your lawyer are not retaining an expert early, if they're waiting to shortly before trial or shortly before your summary judgment motion, they're not doing their job, especially on a complex case where a lot of people may be looking for the same sort of expert, right? Take a delay claim case. Everybody's going to be looking for a scheduling expert, right? And if you wait, you're going to be left with your 10th best option. And I've had mediations where I know who the other party's expert is and I know who my expert is, and I feel much more comfortable with my position just because I know my expert can run circles around their expert, right? So you need to do that early, and it also helps provide a roadmap for where you want to take the case. You don't have to spend a lot of money, but you can get the experts, you know, gut check on what your position is, and they can say to the carrier, hey, we've got issues, right? And you'd rather know about those issues early on than right before trial or right before summary judgment or right before mediation, in fact. So you can all get on the same page at a much earlier stage, understanding that it's going to take some sort of money to resolve this case. And the sooner you get the insurance carrier on board with that idea and that plan of resolution, the better equipped you are to resolve a matter at mediation, because they're going to come to the table with that authority, knowing that their case has issues.
And here's another reason why I like the experts. I mean, in my experience, the best defense is a really great offense. And you can manage all of that along the way. You can manage the cost, you can manage the people, you stay on top of it from beginning to end. But having an expert who's informed about your contracts, the applicable issues at a mediation is very important. It adds credibility and it lets the other side know that we're not just going to pay cost of defense. We're not going to be extorted. If there's a reasonable issue that can be causally linked to our services, then let's talk about the money with respect to that issue. But don't throw a bunch of garbage on the wall and then think that it's going to stick and we'll pay just to have it all go away. That's not the strategy. That's not what leading into mediation is about. It is a very strategic process and a very strategic lead up. And you can do it in a way where it's cost effective, but then allows you, if the case doesn't resolve, I mean, some of these don't after session, you're ready to go. You're not just bluffing, right? There's some bluffing, but you're just not bluffing. You're ready if you need to be. So get those experts.
When you do that, it helps me. And the reason
Yes.
I say that is it arms me with a very powerful tool to go to the other side. And I only do this with your consent, but sometimes I'll have the lawyer talk briefly with your expert to get a sense of how credible they are and that kind of thing, but only with your consent. But
Yeah,
it's-
with me there and my consent, always over my dead body.
Right.
And Paul, it shows you right who's taking this seriously and who's not. If we
Right.
feel as strongly enough about our position as we're posturing to you, and we went out and hired an expert and spent money and brought the expert to the mediation, and the other side has not, you know which side is taking their position more seriously than the other.
And I don't have a problem being very frank with the other side. I always love to use the phrase, I'm so everybody's tired of hearing it from me, but I don't have a dog in the fight. I have no dog in this fight. If I don't settle it, I'm not going to see anybody unless they hire me to do another mediation session, and I don't favor anybody. So I have every reason to say to the lawyer that didn't bring an expert or has weak allegations, where's your expert? Where's your allegations? It hurts your case. You should either take this seriously or give some thought to settling for a lesser figure or whatever it happens to be.
Yep.
It's important that both of you, Kevin and Christine, both, that you consider that seriously and give me the tools that I need to do my job well. So that's my point. We're going to move on now to how a dispute actually gets mediated. And I've already gotten a question in the Q&A. So let me share my screen here for just a minute. Here we go. Share. And then I need to go to a slideshow. Let's see. From beginning. And then we need to go to, let's see if there's a way to do this.
If you just go to from beginning, yep.
There we go. Thank you. So one of the questions that was asked of me, or actually us, was what language goes into a contract to make sure that they have to mediate? And interestingly, as most of you know, the B101 and the custom residential, the B110, are two-part. They're their contract themselves, and then they refer to general conditions, which is A201. A201 has its Article 15, which talks extensively about mediation. And it makes the point that it's subject to mediation as a condition precedent to any dispute resolution, whether it's arbitration or trial. AIA's rule and case law, 2016 and 2017 cases, make clear that if you just go hell-bent into litigation and you don't try to mediate, then guess what? The other side can come in and get a stay and stop your litigation cold because it's a condition precedent to going forward with mediation. We will circulate this language along with other drafts of it, so all of you have all of the different clauses to work with from these various different forms. But I want you to see the 15.3.1 in particular, where it talks about that the claims are subject to mediation as a condition precedent. So let me go back out of the stop share.
And Paul, can I add something there?
Sure.
Here's what's kind of fun from a legal standpoint. Let's say someone sues the architect, sues the engineer, and there's a provision in a fully executed agreement that says mediation is a condition precedent, shall be a condition precedent to binding arbitration or litigation. And someone thinks contracts don't matter, decides to file a lawsuit. There might be a statute of limitations coming up, and they just ignore the agreement, thinking the court's going to go, okay, you can ignore the agreement and you don't have to mediate before filing a lawsuit. The court, upon a motion to dismiss or a demur in California, will dismiss the case dismiss the case without prejudice. But then you have to file it again if the statute of limitations is blown. This plaintiff, whoever's trying to sue you, might not have the opportunity legally to do it again based on this legal technicality, but it's real. I mean, again, the contracts are enforceable, and I've had fun with this provision. Even when they refile the lawsuit, it makes, if I bring a motion to dismiss because someone has filed a lawsuit and there's a mediation provision and no one's tried to mediate before the lawsuit was filed, I can make them and their lawyers look really bad for filing the lawsuit ahead of time. Like, didn't you read the contract? Don't you know the law? So it's worth having this provision in there for so many reasons, aside from what I just said. But it's you don't have to use the AIA agreement if you don't want. You can cut and paste from that. There's lots of ways to tailor make an agreement, but honestly, it's beneficial to every party to the agreement. So I don't know why it's not standard to everything I see on every type of project, quite frankly.
Okay, and Kevin, I have a specific question for you in light of what Christine just talked about.
Sure.
You and I had discussed earlier this idea that the carriers oftentimes ask about the percentage of a firm's projects and or fees that are earned pursuant to an AIA contract and what their claims data suggests. Could you talk about that? This is not a shill for AIA, although I like AIA a lot. What are your thoughts on that?
Yeah, I mean, it's not just the mediation requirement that they're looking for, the carriers, right? There's a joint waiver of consequential damages. There's no indemnity. Everybody's responsible for their own negligence, right? So there's a lot of provisions that are very favorable to the design professional that in turn become favorable to the insurance companies and will help reduce your premium and make you a more attractive risk.
Okay, Christine, do you have anything you'd like to add about that?
Nothing further on that.
Okay, so now we can move into the next area, which is why mediate at all? What's the advantage? Well, first of all, it's clearly cheaper. The cost of a typical mediation process, including the fees paid to the mediator, attorney's fees, and other costs, are usually $15,000 a side or so at the most. It's a relatively inexpensive process for a one-day mediation. Sometimes if you have experts and others, it can be higher, but it's nowhere near the cost of the litigation itself, and especially if it's a long, protracted jury trial. And Kevin, we had talked also earlier about this idea that the substantial savings of mediation have given the carriers an incentive to try to get their clients to mediate by way of deductible. Can you talk about that for a minute?
Yeah, so there's carriers want to settle early, especially in this inflationary environment. Defense costs are going up, expert costs are going up, plaintiffs are more aggressive. It's a longer timeline to litigate, so carriers have seen these trends and have noticed that, and they've gone up pretty dramatically in the past 10 years or so. When I first started working on the carrier side, you would see a claim and you could say, that claim's worth, it's going to take $100,000 to defend that claim. Now you're easily looking at $200,000 to $250,000 for the same type of allegations. And it's been somewhat astounding, actually, to see how quickly these budgets have risen. So carriers recognize that, and they want to provide an incentive for you, the design firm, to go and mediate as well now, and not just say, this is a frivolous lawsuit. We're going to defend this. We're going to get out of it by motion. It's going to take a lot of money to even get to the motion phase, right? So as an incentive to mediate, there's a mediation credit that's afforded to you. So it's typically 50% of your deductible, up to $50,000. You can get back if you successfully mediate a claim. So you're looking at $25,000, depending on what your deductible is. Say it's $50,000. You get $25,000 back if you go and mediate and agree to settle something at a mediation. So it's a good chunk of change, and it's an incentive for resolving these claims via mediation.
Okay, very good.
Can I touch on something that Kevin
Sure.
said? Longer timeline to litigate. That is so important to understand now. It took a long time before COVID, and then you had courts shut down all over the country for months, if not more than a year. The backlog to get your case, even if you have the best case, the best defense in the world, you're not going to see trial for 5 years. And then what happens when you win that case, right? The other side's mad and they file an appeal. Well, welcome to the appellate court world, where things might get resolved also through mediation, but the appellate court's not going to rule. It could be upwards of 2 years. And if the appellate court agrees with your trial court win, congratulations, that took you 8 years. If the trial court disagrees, or the appellate court disagrees with your trial court win, you get kicked back to the end of the line and you start over. So it is years before you can get yourself out of this litigation process in the best of circumstances if you want to litigate on principle. Again, I understand it, but it's not like I'm going to go win this case and it's going to be over, soup to nuts. I never have to think about it again in a year or two. That's just not the practical reality of it. Very important to understand that. So then understand it when litigation happens or before litigation happens. So you have a real good reason to think, maybe I don't want to spend the next 5 to 10 years in the court system. And then what happens in between that? You, probably 10 others from your architect firm, go through depositions about everything from your personnel files to your emails to your text messages while you were building or designing certain towers in Las Vegas. I mean, it becomes really personal really fast. And so the longer timeline to litigate and the stuff that happens within that longer timeline is a real good reason to consider mediation.
Yeah, and you mentioned it, Christine, the frictional costs. You're dealing with responding to discovery that on a matter that may have been a project that was completed 5 years ago, 3 years ago, whatever the case may be. That's real for you and your firms. You could be out performing work, winning new business. There's a lot of lost opportunity that comes with having to deal with the headaches of a lawsuit. But taking it even a step further, every design firm I talk to right now is facing challenges when it comes to talent acquisition and retention, right? So with all of design professionals, a lot of people on the move from time to time, you might find yourself in a position where that project manager is no longer with your firm because you're getting deposed 7 years after the project was completed. Well, guess who has to go and sit for a deposition now for a full day or multiple days? The principal who signed the contract, right? So that can be a really impactful towards your bottom line, actually, having to deal with this lawsuit.
Well, and here's a real world example, and I'm not divulging anything that's not already public record, but I was involved in, along with, tons of other lawyers, the city center litigation, right? There was one point where there were depositions in Toronto for at least 3 months, depositions of every structural engineer, every mechanical engineer, every architect representative who touched the project. Every terabyte from each firm of data was exposed, exchanged, analyzed, and used in those depositions. So it's for those on this call who have not been through litigation and wondering, why am I even talking about mediation? This is, once you see all your email put into a pile and ready to be produced to the other side, and it's email that found its way into the project file or email that the court has ordered you to produce because it hasn't been culled properly, that again becomes another reason why, listen, I don't think I did anything wrong on the standard of care side at all, but it doesn't look good when I was complaining about how overworked and underpaid I was on this project when I was supposed to be observing whether or not rebar was cut. So things like that, like I said, it gets personal fast. And understanding that you can't just rest on your laurels and say, I could do a good job. Unfortunately, you have to prove that you did a good job. Yes, the burden of proof is you're innocent until proven guilty. That's a criminal context, but it's the same, right? The plaintiff has a burden of proving that we did something wrong. The architects or engineers did something wrong, fell below the standard of care, right? And there's a threshold level of standard of care where you can do an average job and it still meets the standard of care. But when you start stacking in the personal emails on any project and the chat, that's where the flavor and the lens by which your firm is judged, it gets, dramatically influenced. So again, get this, understand this, and get into a resolution process sooner than later.
Kevin, one of the participants sent me a chat asking if they participate in a mediation and the matter is resolved, do their premiums go up?
Yes. So the premium is impacted by your loss ratio, right? So if you're settling something in a mediation, the insurance company is going to be paying dollars and you'll be spending money defending the case to get to that mediation. So there's going to be some combination of an indemnity payment and defense cost that goes on your loss ratio. But like I said earlier, once you're sued, it's likely you're going to incur dollars on your loss run, right? What's important after you get sued is minimizing the impact of those losses and keeping your loss ratio as low as possible. So where you get the benefit on the premium by settling is not spending another $100,000 litigating that case for another year or $200,000 for litigating it for 2 more years, right? So you're unfortunately in a position where you're going to have an impact to your loss ratio. Now your job is to minimize that impact.
And let's talk costs for a quick second so that the audience understands in these some of the complex cases, the least of your worries are your lawyer's fees. So a credible scheduling expert on a complex delay claim, right? Let's take the Regional Justice Center and the Clark County Detention Center, right? That thing took forever. But the expert costs for a true credible schedule analysis, you could see in excess of $1 million. And we're seeing that. And you know, your legal fees are going to be in the millions, not just a few $100,000 on the complex construction side. Yes, that's all managed through budgets, and it's not like all of a sudden your lawyer goes from 0 to $1 million. It's managed all along the way, but the expert costs on a case that is going through trial will dwarf the lawyer costs. They will. And yet they're going to be 100% necessary to your defense. You can't have a plaintiff who has a scheduling expert and the bankroll to present the claim against you. So big general contracting firms, what do they say? Projects delayed because of change orders caused by the design team. They sue the owner turns around and sues the design team. Well, the general contractor is bankrolling that litigation, and they have the money to do that. And they're paying their scheduling expert $1 million+ to prepare a schedule showing why you impacted the critical path and thus are responsible for the millions of dollars in delays. Now, we all know after decades of doing this that a lot of times that scheduling expert is full of it on the plaintiff's side. I'm sorry. But what does that mean? That means you need a scheduling expert on your side, design team, to prove and demonstrate why X is not on the critical path, Y is not on the critical path, Z is concurrent delay, and it's expensive. It's very expensive to do that.
Okay, we're going to jump a little bit because of time.
I can take a hint.
Sorry?
I said I can take a hint, Paul.
Wasn't intended.
I'm kidding.
On the other hand, if the shoe fits. I want to jump to the topic now, and I'm going to get out of the way because in a sense, the two of you are much more able to answer this objectively than I am. But we talked a lot about the topic. How do you pick a mediator? What are the things you look for in picking a mediator? And retired judges versus attorneys. And Christine, you and I talked at some length about that particular issue too. Kevin, do you want to start with your thoughts on that, and then Christine will pick up?
Yeah, sure. So yeah, I mean, it's very important to pick the right mediator. Not only the right mediator with subject matter expertise, hopefully someone that's done real estate or construction law like Paul has, but also a mediator with the right temperament, right? You can get to know your client a little bit, understand opposing counsel. You can start to figure out what mediator you think might be the best fit to actually resolve this case, right? From where I sat at insurance carrier side, we have these big national mediating companies that employ a number of mediators. And oftentimes, I mean, mediators are pretty expensive, generally speaking, but oftentimes those gentlemen or ladies can be a little more expensive, right? So I oftentimes will look to counsel like Christine to see if there's someone better locally that might be a fit for that case, right? And oftentimes they'll respond with a list of potential options, and we'll go through them and we'll talk about the strengths and weaknesses of each mediator as we perceive them to be in conjunction with the litigation we're dealing with. And I'll defer to local counsel most of the time. I'm not sure every carrier operates the same way, but that's been the most effective way, in my opinion.
Okay, over to you, Christine. What are your thoughts?
And practically speaking, if you look at a construction case, and there are no less than 5 parties to the case. So every party has a lawyer and every party has an insurance representative, more often than not. And all 3 need to be consulted to agree upon a mediator. So what practically speaking will happen is there's an agreement to mediate. The parties will agree, let's circulate 3 names that we all agree. If there's a common name amongst that list, then that's going to be the mediator. And mediator is called to check availability, and then you're off and running and it's scheduled. But you need to have the design team, you need to have the collective agreement and recommendations from your lawyer and from your insurance company. Why? Because we've seen the good, the bad, and the ugly mediators. I talked with Paul about this, and I respectfully am one who will prefer to choose practicing lawyers who practiced in construction law as opposed to retired judges on most cases.
Yep.
Why is that? Because the lawyers have seen it all. They've seen it and they've litigated it, not just seeing a law and a motion once in a while, like the judges. So judge sitting on a bench doesn't just dedicate himself or herself to construction cases from beginning to end. Although even if they're in a dedicated construction law department, they're not seeing, what happens in depositions. They're not seeing necessarily what happens in anything other than the motion before them or the trial before them that ultimately gets settled in the middle, so they don't see the whole thing. So it's not disrespectful, but in general, my preference is to get a lawyer with a lot of experience in construction law, also experience specifically in representation of design professionals or understanding being involved in cases involving design professionals, or mediating design professional cases. Again, why? Because you need to understand the different disciplines, what you design professionals do and what you don't do. What the difference is between supervising and observing, the difference between a shop drawing and a shop drawing stamp and a stamp by an architect of record. All of that has to be understood. Otherwise, mediation is not going to be productive. Where judges are important, and you'll sometimes see this, if there's a personal injury or a death case. So one of the cases, I handled quite a few bridge collapse cases, and unfortunately catastrophic death, catastrophic personal injury and death. And the plaintiffs in those cases who are suing, all the design team, all the contracting team, everyone they can sue, really want to have a judge involved. And there is something to be said about having the robe present, but what'll happen in that scenario most of the time is the judge also understands that he needs or she needs to have a mediator involved. So the judge will reach out to Paul, or the parties will reach out to Paul or another mediator and say, this needs to be co-mediated with a judge, so that these plaintiffs understand that this is enforceable and they have some comfort with the system. But then the mediator understands all the details as to why the bridge collapsed or the balcony collapsed. So,
Okay. Kevin, anything else you'd like to add on that topic?
No, I think Christine covered it. You can move on.
Okay. Then we're going to turn to, I think we'll probably be close to the last topic that we want to talk about today, and that has to do with how the professionals interact with their counsel. And what I mean by that is, if you have a claim, what is your lawyer going to expect of you, and what are you expecting of your lawyer in the process of getting ready for the mediation and actually participating in it? And Christine, can you give your thoughts on that, since you're sort of right at ground zero there?
it is something, I'm just going to say, interaction with your lawyer should be early and often. So if for some reason you've got a lawyer who's not trying to get key project documents from you immediately upon the case being assigned, and in some cases an insurance company will assign the case. In many cases, it's you, the client, calling me, the lawyer, saying, all right, heads up, this is coming in. And then we loop in the insurance company. But the interaction needs to start quickly. A couple, reasons for that from a legal standpoint also is the culling of the electronic information. There are real specific laws out there and statutes out there now that prevent you, the design professional, from deleting or moving or altering electronic project file information at all when you become notified of a potential claim. So they have litigation hold, what they call litigation hold requirements, and all of these requirements and the practical reality of how to respond and preserve and make sure you're protected, it happens really early. And if you are not on the phone with your lawyer and your law firm assessing all of the things that you, the design professional, need to do now that a claim or potential claim has arisen, then you should be nervous, because it's not just how do we cull electronic information, preserve and protect, but it's also how do we make sure that we are doing what needs to be done from our insurance company's standpoint. So there are notice requirements with your professional liability policies, claims made and noticed, right, Kevin? So if you don't report a claim that's been made, then you're jeopardizing your ability to get insurance coverage. So again, you're going to get that from your lawyer who's familiar is the wrong word, your lawyer who practices professional liability construction law.
Yeah,
He or
and
she
one
is
other
going to be able to
important,
tell you.
yeah, one other important thing to add there is the litigation hold is a perfect example of this, right? So when you report something to your carrier, it could either be a notice of a circumstance or notice of a claim, right? A claim is defined as a demand for money or services, right? So a notice for a claim might not even start to incur defense costs immediately, but if you do incur defense costs, it will be counted against your policy. When you have a circumstance, which is what a litigation hold would be, there's no demand for money or services. The insurance company pays for all costs until that matter becomes a claim, right? So there's a significant benefit to you all to report that matter early because you're not paying any money and it's not going to go against your loss ratio. And you can, in fact, use dollars there that would otherwise need to be used in litigation. I've engaged experts in the pre-claim phase and spent hundreds of thousands of dollars on experts, and none of that counted against the policy. And I did that because I was hoping to spend that money to avoid a lawsuit, right? So the insurance company, once again, harping on the fact that you need a sophisticated insurance company that understands design firms and their needs and how the litigation works, might be able to be a huge value add in that scenario because none of that money will count against your loss ratio or impact your future premiums.
Yeah, that's huge. I mean, there we have, the pre-litigation, pre-claim, loss prevention, risk management, the sophisticated insurance companies who represent design professionals, write for design professionals. It's really, I think that's underappreciated, or maybe it's just not known, but it should be accessed. And the lawyers who are communicating with you early and often should be communicating with you about that type of thing, which is, are there any, is this a program where until a formal lawsuit is filed, is the insurance company paying for everything? Yes, in many instances. Is there financial incentive to settle in mediation? Yes, there might be a mediation credit. I mean, these are things that you, the architects and engineers, might not know about, but your lawyer and your insurer are going to be informing you early and often.
Yeah, and one of the other scenarios, this is getting a little bit off topic, but I think it's important. One of the other scenarios where pre-claim assistance is really helpful is if you have a project where you're starting to have a little bit of an adverse relationship with the contractor or the contractor sending you letters that seem accusatory in nature. Notice your insurance company, because the first thing that I would do if I was receiving that notice is go and hire someone like Christine, and she'll be there for you to help draft a letter that would go in your letterhead, not on her letterhead, and respond to the contractor's allegations in real time. And that is, you couldn't have a better benefit going into litigation than having a lawyer drafting your correspondence for you during the course of the project.
And that's I've done that so many times. It's incredible. And you design professionals know when there's a setup going on, especially on the delay claims. All of a sudden change order logs miraculously say everything's the fault of the architect or the engineer. And it's just, I hate to say it, but in this day and age, if it's not on paper, it didn't happen.
Yep.
So if you don't have a file that's papered, if you don't have something in your project file or many things in your project file articulating why, listen, I don't agree with this, or here are the reasons why this isn't our issue, or then when litigation happens, you're then trying to recreate history, and it's not good for you, the design professional, in that scenario from a factual standpoint. And Kevin talked early about course of conduct, and the course of conduct during the actual construction of a project obviously necessarily involves most of the architects and engineers on the design side, depending on the delivery method. And the meeting minutes, look at those meeting minutes. Those are a treasure trove for me as a lawyer when I am opposing a contractor who says everything was awful and substandard and it's the architect's fault, and yet I've got meeting minutes where no one's complained about anything material against the architects or engineers in them.
Or the action required column shows that the contractor was supposed to respond to that topic that was raised during the meeting, right? So, and obviously Christine hit the nail on the head. If you're litigating and you're sitting in a deposition relying on a verbal conversation that happened 7 years ago, guess what? You're in for a very long deposition. It's not great. You need the documentation to back up your position.
Yeah.
Okay, the last topic that I want to talk about, and this kind of falls to me, and then we have a lot of questions that we're going to answer. So I'm going to ask everybody with a question in a few minutes to resubmit, and we'll take each one of them and answer it live. The last topic has to do, what do I do? What's my role in this thing as the mediator? How do I do what I do? And in a sense, it's a little like the Wizard of Oz, where I'm coming out from behind the curtain, and instead of this all-powerful being, I'm actually just a guy that had been in this field for a long time and then got involved in the mediation of it. What I bring to the table and what you want to use from me are my skills with people as well as my skills in the field, because some clients are more volatile than others. Some clients are more verbal than others. Some clients don't get along with their lawyers and others do. Sometimes a lawyer has very little client control. These are all problems put on my desk. And those are the things that I have to solve as the mediator. I have to get to the bottom of, how did this get here? Was there a communication breakdown? And how do I deal with the problems in the situation on the ground, in the sense if there's disruption in the relationship, what happens? And I'm going to tell one very brief story that I think is very illustrative of what I do and how it can sometimes benefit the litigants in a way that a court matter can't. I represented, actually I didn't represent, I was a mediator on a mediation involving a very well-known architect in Southern California who was in litigation with a city. And he and his firm had a very well-established reputation for what are called splash parks. Until I got this case, I didn't know what a splash park was. But this architect had cornered the market on splash parks, and he had somehow alienated one of the municipalities he was working with because there were delays in getting the project done. And there were some questions with Southern California Edison and others about extra power that needed to be brought to the project and some other things that got involved. He needed his reputation protected. He needed to be able to go back to other municipalities and continue what for him was a very lucrative practice. And rightly so, he had done great work for a long period of time. But municipalities talk. I'm sure any of you that do work with municipalities know that the city managers belong to their own organization. They talk among themselves. If he alienated them and they wound up in litigation with him over one of these, then that would become public and common knowledge. He was understandably very upset. His lawyer was really understandably very upset and very volatile. I had to do the unprecedented thing as a mediator. I'd never had to do this before in 20 plus years. His lawyer said, I don't want to come. And I don't want my client to come. I said, you are, using Christine's words, going to drag your butt down here now. I said, there's too much at stake on the table not to get this resolved in person. The city attorney came, the city attorney's associate came, and the city manager came. And this thing would have descended into chaos if the architect didn't come. And the architect was relying on the advice of his attorney, which I thought was craziness. I made them come. We settled the whole thing in a day where I sat in on a meeting with the city attorney and the architect themselves because their families had known each other for 20 plus years. And I got the consent of the architect's lawyer to do it. And they broke bread. They came to a mutually agreeable settlement and the case resolved. This is what I do. This is what the mediator does, is to grapple with and deal with problems like this in the course of what they do. The lawyer can only do so much. They're not God and they can't wave a wand and solve everything. They can only give me the tools that I need to do the best job that I can and be responsive and not a roadblock or an impediment. And I've had both, and it makes my job a lot harder. The last thing I want to talk about before we go to the questions is, if the case resolves, it is critical, not important, but critical, that it gets written up that day in a signed stipulation. It can be, as Christine pointed out, on a piece of 8.5 by or 14 legal pad in handwriting. It does not have to be written, but it has written or typewritten, but it has to be in writing and signed by the parties. This is critical because people change their minds. It's human nature. They go home, sleep, and they go, God, I could have done better. It's just part and parcel of the process. It's critical that you capitalize on everybody's meeting of the minds at that moment so that the settlement is final and permanent. The lawyers can draw up a longer form, and often do, a longer form settlement agreement after the stipulation is entered into. But the stipulation in and of itself is enforceable under our Code of Civil Procedure section 664.6 as a judgment. Once that's done, it's done. That necessary finality. I have lawyers all the time saying we need it to be final. I get it. 100%, I get it. That's why I'm there, is to get it final if we get it resolved. So I keep people 10, 11, midnight all the time. I let my assistant go home. It's not fair to keep her there. But we'll stay until it gets documented, and we make the 16 copies for everybody and their brother. And they go home and the case is resolved, it's finalized. That's what you go to a mediation for, not to just shoot the breeze, but to get something resolved. So thank you all very much for your attention and your concentration. This has been a long, but hopefully informative session for you. And all of you that have questions that they didn't get answered, unfortunately, because of the need to get the material out, please resubmit and we'll take and answer each one live. So I'm going to take the first one that's on my screen and let's see here. Okay. It is becoming more prevalent that an owner requires us to carry the geotech and survey. How can we cover?
No, sorry. Sorry, go ahead.
Oh,
I heard
sorry.
owner requires architect to retain geotech and I slipped out. Go ahead.
Okay, well, this is your opportunity to flip out, because what's your comment about that, Christine?
Okay, sorry, what was the question? I just heard the owner was requiring the architect to retain the geotech more and more lately. Was that the
Yeah, it is
question?
becoming more prevalent. Owner require us to carry the geotech and survey. How can we cover ourselves in that
Yeah,
scenario
I mean,
for future litigation?
I think
Go ahead,
Christine would
Kevin.
agree. As a broker, one of the things I help my clients with now is developing a client selection process and go and no-go terminology. From when you see language in a contract, that means we are absolutely not accepting that risk. That could be a bet the firm type of provision. This would go firmly in the no-go category, where I would walk away from the project. It's absolutely insane. From an insurance standpoint, geotechnical errors cause not just more frequency of claims, but also the highest severity type claims. So it's a really dangerous area to put yourself in and have that geotech in your umbrella, and for you to be vicariously liable for that geotech. If you are absolutely required to do that, I would make sure you hire a geotech with hundreds of millions of dollars of insurance coverage, so that they're paying the entire freight of a claim where it's their negligence that caused the claim, and none of the vicarious liability gets pushed up towards you.
And here's something that I hope is helpful. It is an owner testing the waters. It is not done. It is
Right.
rarely done.
Right.
And I'm on every kind of transportation project involving geotechs. I represent the geotechs and I represent the architects, and I represent the architects when they're negotiating the contracts with these owners. And you know, you have a developer who's got general counsel inside and they're like, all the disciplines need to be under the architect. Well, that's just not true. And historically, that's not the case. And it's really not the case currently either, but they keep trying to do it. And really the reason is, listen, the geotechs, unfortunately for that profession, if the building sinks in San Francisco and tilts, the geotech is going to get sued for millions and millions of dollars, even if the fault is others, right? If the geotech is under your umbrella architect firm, then you are going to arguably be vicariously responsible when the geotech runs out of coverage or can't get coverage to cover that claim. So then that becomes an architectural problem. It's a hard no. And then if you need a lawyer to talk to the lawyer on the other side, trying to get you to accept that scope, reach out to your carrier and said, I need help negotiating this contract. Or, I mean, I'm not promoting myself, but it's really one of those things where it's like, oh, come on, you're not serious. We're not doing that. We're not going to have geotech. We're not going to have the surveyor. We're not going to have the ADA consultant. You can have that under your scope. And then the developer says, oh, we want you to do it all. It's like, okay, that's nice, but we don't do it all. So go get the team on your side of this pyramid, and you keep those geotechs out from under you.
Yeah, and having a lawyer to negotiate it like Christine is the way you push back there, right? It might be something that's the owner holds a lot of the cards in the negotiation phase, but this is absolutely one where you need to push back on. And Christine's telling war stories now, so she referenced the Millennium Tower project in San Francisco. Can you give the audience, Christine, an idea of how long that litigation went on for and how much it cost? It's still,
I actually can't, but it is ongoing.
It's a nightmare. We'll just leave it at that. It's a very protracted litigation. you can tell us when it started, right? That's a matter of public record, right?
Well, when we discovered the project files from the developer, it started a heck of a lot earlier than the lawsuit was filed, years earlier.
Okay.
So a lot going on behind the scenes that ultimately became part and parcel of litigation. But so that's 2009, roughly, until now. And there are issues, so I don't want to talk too much about it.
Yeah, that's fine. But I think that this feeds into why the geotech, in that instance, it's taking such a long time to find out where the liability lies, and geotechnical errors are tough, are challenging to devise a remedial fix for, or even determine where the liability was, right? So that's one of the primary reasons why this needs to be kept out of your scope.
And here's what happens. So the geotech most likely was paid the least amount of fee. The geotech likely has the least amount of insurance.
Yeah.
And so a developer trying to access all available pots of money to try and resolve a claim worth hundreds of millions of dollars potentially, and I'm not just talking about Millennium, is going to then argue that the global architectural firm with a much bigger policy and potentially more in excess of that is a better pocket to access. So if it makes the argument too easy for the developers to then blame the architect for the geotechnical if the geotech is under your umbrella.
Yep, it's a nightmare.
Sorry, it was a trigger.
Okay. Next question is, some people say that liability insurance, when not legally required, can make a design professional a target for litigation. Agree? Disagree?
Wait, run that by me again. What was that? Sorry.
Some people say that liability insurance, when not legally required, can make a design professional a target for litigation. Agree or disagree?
Yeah, I couldn't disagree more. And that's not only because I make a living in the insurance world. I mean, it's something that you need to carry. I think, in our notes for this presentation, if you haven't been sued yet as a design professional, you're in the lucky few that can claim that. The frequency of lawsuits against a design professional is just astounding. And when you get sued and you don't have that coverage, you'll realize very quickly that you needed the coverage. You're just spending money out of your own pocket monthly on legal fees. And I don't know how you can run a firm like that, right? It's very problematic from just a business standpoint. You need to protect your biggest asset.
And I've heard that said before. I've heard that discussed, where it's like, listen, the only reason I'm being sued again is because I have liability insurance. And it's not true. Unfortunately, architects and engineers, you're going to get sued no matter what you're doing. Right. That's the reality of this situation. And when the existence of liability insurance is going to allow you to sleep at night, I mean, God forbid, when there's personal injury, man, you're happy that you have liability insurance, right? When there's real damage, and I say real damage, it's when there's death and there's injury, right? And no amount of money is going to help someone often get better, or obviously, especially if someone has been killed, but is going to allow you to continue to conduct business. It's going to allow you to sleep at night, and then more often than not, resolution with good lawyers and good carriers is going to come within a reasonable range of your actual exposure to the issue.
Right.
So you're not getting sued because you have insurance and people think that it's a blank check on the other side. And to the extent that is a misperception, when you get sued, your lawyer's job is to make it very clear to the other side that there's not a blank check. Professional liability carriers care about the facts. I care about the facts, and my client cares about the facts. So the facts matter, and we're not paying you a dime until we can actually see what our potential involvement and causal link to this damage is. So from a business standpoint, you need to have the insurance. You really do. It just, I don't.
And a nuance to this argument, which I do tend to agree with, is what I'm seeing across the board when I review contracts is escalating limits requirements, right? Someone, maybe it's a state agency, maybe it's a certain developer, they're requiring that each and every design professional carry 5 million of insurance, where in the past they only required 1 or 2, right? And in that instance, that's another area where you can negotiate with the owner, the developer. You can let them know, based on construction value, based on my scope of services, based on all these different factors, this is why I only need 2 million, because what you don't want to be doing is for each and every project, having to go out and get an endorsement for increased limits based on a contractual provision, or having to buy more each and every year because all of your contracts have these increased limits where it's not really appropriate for the type of work that you're conducting.
Okay, next question says, survey is typically under civil, so we roll up both if we engage civil.
Yeah, I listen, I understand that. I've seen it structured like that as well. You just need to make sure you have the flow down provisions in place where the civil is going to be carrying enough insurance to cover any sort of surveying error, and the it's not going to flow up vicariously to you. If you're required to carry $5 million of insurance by the owner, you also need to make sure that your civil, who you're engaging, is also carrying $5 million worth of insurance, right? There's ways you can do this to protect yourself, but I would highly encourage taking the surveyor out of the design professionals umbrella.
I would too, but then I will, with that said, separate the surveyor from the geotech. So truly under no circumstances do you want the geotech under your umbrella.
Right.
Under most circumstances, you don't want the surveyor under your umbrella. Correctly, if that happens within the civil scope, again, like Kevin just said, make sure there are flow down provisions and indemnification language where the surveyor and the civil agree to indemnify the architect for damage caused by the negligence of the surveyor. Things like that can be done contractually, but it's really important to do it contractually up front. Don't think it's something that can wait until the end. I've also seen some provisions on the public sector side, transportation projects, where big architect firm is just like, they're making us carry the civil and the surveyor, right? And there's some pretty crafty, creative language to make sure that in the event of litigation, in the event of liability, the owner expressly understands that in that context, the owner is, responsible solely and directly. Whatever needs to be said, it can be done contractually, but it needs to be done right. And it needs to be done at the time that you're negotiating the contract on the scope of service.
Yeah. And one other item to add there with the surveyor, surveyors perform two types of services, right? They perform the survey itself. They provide that documentation. And there's also staking responsibilities that goes into what a surveyor does, right? So you need to reference your insurance policy and the definition of professional services and make sure that those services are covered, because if staking is considered a construction activity and not covered, you're going to have some real problems there if a claim comes in because someone staked a project incorrectly, and you're not going to have coverage. And you can use that in your negotiations with the owner developer to say, I can't have the surveyor under my umbrella because that's not a covered risk. And the owner doesn't want that either, right? You don't want any coverage gaps going into a project. The owner should understand that, retain the surveyor themselves, make sure that surveyor has appropriate coverage, right? And it can come out of your umbrella.
And that really is the best argument. It's like, listen, owner, on page 15 of this contract, you require me to hold $5 million of insurance for professional responsibility, professional liability. So I'm going to get that insurance, or I have that insurance, but now you want me to carry the surveyor, and the surveyor could potentially create a coverage dispute right out of the chute. So how about we do this? You carry the surveyor, you definitely carry the geotech, and then we've got insurance, we've got the right contracts. And if there's an issue, you can access the surveyor directly and you don't have to go through us.
Yeah.
Okay, we have 3 questions on the boards. We're going to answer these 3 and then call it a day, because there are people behind us and I'm starting to get hoarse. So the first of the 3 says, no ADA consultant under the architect. Can you explain that further?
Other than if there's an ADA claim, those are animals in and of themselves. So litigation involving ADA claims, Mandalay Bay was a big one. The architect in general, the ADA is a really specific scope that normally the architect is going to want to separate itself from. And so the owners typically, especially on the hospitality projects, retain the ADA directly. ADA consultants directly. I've seen it done where the architects are also retaining the ADA consultants. I think it's just because, kind of like a trauma surgeon, I've seen it go bad. And when it's an ADA claim and the architect has done nothing wrong except for having the ADA consultant under its umbrella, the architect gets dragged into the litigation, even though for all intents and purposes, the architect didn't wasn't even involved in that scope aside from the contract. So it
Yeah.
becomes the nature of the contract if you can't just get the owner to agree to take that scope directly. It doesn't mean you're not going to coordinate the consultants or they're not going to coordinate their work with you.
Right.
But yeah.
I've seen claims too, where the owner has hotel claims similar to you, Christine, where the owner has retained their own ADA consultant, but there's certain coordination that needs to take place from the design professional of record and that ADA consultant. And if you're not adhering to the protocols and not getting them change orders or scope changes or design changes, that can lead to liability for you. And one particular instance comes to mind where the architect's contract said they were going to perform ADA services, but they didn't. The owner retained their own, but once they started failing to adhere to the protocols, it became a real problem for them, and there was real indemnity exposure. And just ADA suits, generally speaking, are on the rise, and they oftentimes lead to significant payouts because you're dealing with something like a hotel or an apartment complex where the mistake is repeatable, right? So say there's an issue with the doors, the widths. You're not just fixing that issue once, you're fixing it 500 times, right? So that's a costly claim, and I highly encourage you to keep that out of your scope as well.
Okay, next question. How has general contractors' wrap insurance programs affected general liability for design professionals?
Yeah,
Go
so
ahead,
I
Kevin.
just did a presentation on wraps in July, and generally speaking, it's a program for the contractor, right, that covers a lot of those issues and makes it easier for them to resolve those claims. So generally speaking, it helps protect the design professionals. I think it's a good product for a contractor to carry on a project of any size.
Christine, any thoughts?
I agree. Just make sure that it's actually covering the design professionals. A lot of time there are exclusions where design professional services are excluded from a wrap. So just make sure that you're actually getting that you're getting the language in those policies and you're getting included in them. So
I thought you were going to disagree with me for a second, Christine.
Kevin, I don't disagree with you.
I don't want to be in an argument with you, Christine.
No, you don't.
Me neither. Okay, last question. I am limiting my liability to the amount of my fee in the contract. Can I be sued for the amount higher than that?
Yes, you can get sued for any amount, and a judge is going to have to rule on that provision of your contract to make sure it's enforceable. In certain jurisdictions, they're not enforceable, actually. So you need to. It's a great provision to have. I encourage you to get it into each and every contract you have.
I mean, that's
Steve will speak further, I'm sure.
Yeah, that's a great. I mean, it's a none of this actually prevents a lunatic from suing you. And I'm sorry, but a lot of developers, in my opinion, the lawsuits that happen, it's happened too quickly and too easily. So you're going to get sued. And then how are you going to get out of that lawsuit? Through what we call law in motion early on, where I can look at your contract and there's a limitation of liability clause in a jurisdiction where it's enforceable. So if your liability is limited to the amount of your fee or a certain dollar figure, whichever is less, that's a great clause to have. Then it becomes a legal issue for your lawyer to go before the court and say, we want the court under declaratory relief action to agree that this clause is enforceable. And then, if you go then write a check for the small amount or whatever it is, however you can resolve it, it's a great tool in your toolbox to have when they're enforceable. So you'll get a lot of pushback and legal back and forth when you're in litigation. But if you can get them in your contracts, it's a good thing to have.
And it's you don't have to limit it to your fee, right? It could be limited to a certain value where you think your maximum liability might lie. You can limit it to available insurance, right? So you can, if the owner says no to limiting it to your fee, there's other steps you can take to still try to get a limitation of liability in there that protects you somewhat.
Okay,
go ahead.
You're asking now what jurisdictions in the Western US are limitation of liability, the amount of fee not enforceable. I'm limited to California. I think there's a case called Markborough here in California that says that they are. And I think there was a later one too, but I don't know other states. Do either of you?
I think
Nevada, they're enforceable. California, they're enforceable.
Yeah.
And it's, especially between sophisticated parties, which you have design team, a developer, anyone in the industry, it's where you'll get questions if you have a one-off homeowner negotiating an LOL clause with an architect, then they might say, I didn't know what this meant, right? That's their best argument. But in general, in our industry, in the states where there's a statute or a case on point, it's going to be enforceable. It's super.
Okay, we're going to conclude now. And
Oh,
I'm
I'm sorry, Paul, we had
Yes.
one more question that was in the chat, if you guys can answer that.
Is that the one that says we've been asked to carry the third-party
that's it.
inspector?
Yeah,
Under the architect's contract, we are not comfortable doing this. Is this a no-go? It's a no-go. And I just said, don't do it.
okay,
Yeah.
thank you.
Yeah, I would
Okay.
put that in the no-go category.
And it's not done. It's really not done. And
I've
there are
never
a
seen
host of cases out there, claims where third-party inspectors have been sued for a whole host of reasons. So I haven't in 25 years seen this scenario on any of the projects where the architect has retained the third-party inspector. So if your developer owner is telling you, you have to do this because this is the way it's done, you say, no, I know a little bit better. It's not, right?
Agree.
Okay, to any of you still there, our contact information is on the last page of the PowerPoint presentation that AIA will make available to you. And we've also included several different drafts of language for mediation clauses in contracts, one of which is from the California Association of Realtors, AIA, and a couple of custom drafted ones at all. We can't, for liability reasons, say, do this one, do that one, or others. These are just for your suggestions as a starting point. We thank you again very much for your patience. This was a long presentation, certainly was for me.
It was fun.
It was a lot of fun, though, a lot of fun. I really had a good time. So
Yep.
good luck to all of you, and we'll sign off now.